So you have a heading for Fourth Amendment. You see these bold headings, these are the ones that you sort of minimally need to have. The other non-bolded headings you can have, depending on how you want to structure your exam, you could break it up, search and seizure, government, conduct. But you at least need to have Fourth Amendment if the Fourth Amendment is at issue. State what the Fourth Amendment is, so there's a general rule there. Protects the public from unreasonable searches and seizures conducted by the government. And then you want to add there that this is incorporated to the states via the 14th Amendment. So that's in our newer version, I'm pretty sure, but we always add that. So this is incorporated to the states via the 14th Amendment. And then your next heading would be exclusionary rule. And this is just, the only reason why it's the next heading is because the bar examiners have told us that. They haven't said memo, all examinees, first heading, second heading, but they might as well have done that, right? In their answers, they've done that. If you look at 10 Crim Pro exams, they pretty much go the same way. Logically, exclusionary rule really should be at the end. It doesn't make sense that it's the very next thing, that it's somewhere in the top of your essay. But it's what they want. So it's what you're going to do. You're going to state what it is. And then if you ultimately decide something is excluded because of the exclusionary rule and the defendant's Fourth Amendment rights were violated, then you could have a heading for fruits of the poisonous tree, or you could have a heading application of the exclusionary rule, but you ultimately would handle that discussion at the end after addressing everything else. And I'm kind of assuming you all know what this is because I know you do, right? You do. So you're going to have Fourth Amendment, the general rule, it's applicable to the states via the 14th Amendment, exclusionary rule, sentence or two there, and then you address whether or not there was a search or seizure conducted by the government. And that can all be wrapped up into one concise, 3-4 sentence paragraph. Here there was a search of so-and-so's apartment or so-and-so's purse, or it was seized by the police, the government, therefore there was a search and seizure conducted by the government. Then you go to standing, has to be a separate heading, and standing is shown two ways. Either they have a reasonable expectation of privacy or a substantial ownership interest in the places searched or items seized, right? This is stuff you know. And if you don't have it exactly at the tip of your tongue, it's pretty easy to get it back, right? But having a flow and knowing what has to be a heading, that's really important. So you address all of that to determine whether or not they have standing, and generally they will unless you have multiple calls where you can kick something out and you have standing somewhere else. If you have a warrant on the fact pattern, you'll talk about it. If you don't have a warrant on the fact pattern, you skip all of this, everything on the rest of this page. There is no point in telling them the definition of a warrant if there isn't one for you to evaluate. Don't waste your time, they don't want it. If there's a warrant on the fact pattern, then you absolutely need to set out what the warrant requirements are, and you'll likely have a place that is weak, because they always want you to go to the next page, which, take a look at the column. So you won't address a warrant unless there's one presented to you, and then you show the elements, and maybe there was a problem with the applicant where the warrant was executed on the wrong unit. If that's the case, and there was no bad faith on the part of police officers, then it's probably saved by good faith. But you have to assume that you still have to cover the fact that it might be kicked out. And therefore you have to go to the exceptions to the warrant requirement, even if you have a warrant, because there's generally on the essay going to be some basis for it being defective or faulty. So if you don't have a warrant, you go straight to the exception. So this is really pretty straightforward. You'll notice the big text, if you can see that at the very last column. The reason why I've done that is that's pretty much only on the MBEs. But I don't like to give essay-only materials and then, oh, yeah, there's also administrative inspections. Just worry about that when you get to the MBEs. I want you to be thinking about all of these things whenever you're reviewing. So if you're reviewing for the essays, the first 1, 2, 3, 4, 5, 6, except for the last column, are all highly testable on your essay, and of course on the MBEs. But we've really never seen much in the way of administrative inspections, but you could, right? So you want to be aware of it. It's just not something I would really worry about memorizing every single line of or spending too much time, because as long as you're getting the MBEs right, you should have that covered. But the first 6 columns are critical. So look at search incident to arrest. Most people will pick up on that. But if a defendant is arrested in their home, something was taken off of their person or from their pocket, then you're going to think about search incident to arrest or search incident to a lawful arrest, however you want to say it, it really doesn't matter. But you validate that search by the fact that it was incident to an arrest that was apparently lawful, right? Could have been a hot pursuit, whatever it might be. What you may not know is that whenever there's a search incident to arrest discussion on any bar exam that I've ever seen in California, there's also included a moving wingspan discussion and protective sweep, even though neither one of those happened on the fact pattern. They want to see it. They want you to say that in addition to this search, they would be entitled to conduct a moving wingspan search, which would entitle them to search anything within the defendant's moving wingspan. Even though she didn't move and even though she was handcuffed, right? You need to state that. 2 sentences, but it makes all the difference.